Morning to you, David.
Good morning, John.
Just to repeat what I've already announced this morning, the class action against the directors and company of Slater Gordon for 17,000 small shareholders has settled this morning, $36.5 million.
Wow.
32.5 from the directors' insurance. That's directors and officers' insurance for, directors fulfilling their duties. And $4 million from the hedge funds that are wanting to recapitalise Slater Gordon and then try and turn around their last few years of misfortune. So that's another big... Morris Blackburn have run the class action. There's two on foot and one foreshadowed. The other two small ones are thought to be of no consequence
in the great scheme of things,
to the future financial prospects of the company. But this one was the big one, $36.5 million.
Well, we talked about it last week, and I thought, well, you've got to at least know where you're going in the class action. And I read I read this morning's paper this morning, so I was running a bit behind, and I saw that the deal last week was conditional upon a settlement in the class action, and came in this morning, and I find out that it's settled.
Yes, it has settled.
Somebody blinked.
Yeah. Well, yes, I think there was an extra. I can now say what I knew last week wasn't allowed to say, which is that they were talking around the 35 million mark. So the extra $1.5 million is the amount that it's gone up by in the course of a week. So $1.5 million for a week's negotiation.
Depends on how many lawyers were involved. Huh?
You'd need a lot of lawyers involved to chew up $1.5 million in a week. But that was the difference between where things were a week ago and where they are now. So there you are. That's what was happening for the extra week. And that means that Slater and Gordon can try and get back to actually doing business instead of obsessing over their entrails.
They can focus on looking after their clients.
Yeah. And the other big thing we've talked about already this morning is that the lack of enforcement by the DPP here in Victoria over any number of people who are committing any number of breaches of the laws of contempt and sub judice in relation to, in particular, Cardinal Pell. There's been a bit of a media free-for-all, and I do not understand why they're sitting on their hands instead of doing what happened last week with the Court, or 2 weeks ago now with the Court of Appeal, saying, oi, you, bad, come in here, sit down in front of the judge, explain yourselves, because we're not going to let this keep happening. If we're going to actually stand up for the integrity of the legal system, we have to start right now.
Yeah, we have to, in a sense, look after the defendant. Says the presumption of innocence.
Totally.
We've got to make sure that that maintains.
Because there are any number of people who see it as being in their interests to try to either sell papers or attract people to their media outlet to try and push the boundaries and say things that, quite frankly, should not be said.
Yes, like a report the other day of
don't repeat it.
I wasn't going to. Phew. I wasn't going to. A coffee shop in Singapore, so yeah.
Yeah. So anyway, we will see what's going to go on there. Any other news?
Well, one which is one of those beautifully obscure things from a lawyer's perspective, and it relates to what constitutes a retail lease. So there's been a matter, a cold storage facility ran a lease, and the question is the lease a retail tenancy? So they ran a cold storage facility, any customers, and the presumption was, from the landlord's point of view, that it wasn't a retail lease. And the Court of Appeal has held that because it involves the retail provision of services, that is, services that you supply that are consumed by the customer, it constitutes a retail lease. Now, that will terrify a whole lot of landlords and a whole lot of landlords out there, because with a retail lease, the landlord doesn't get to keep the land. The landlord can't pass on the land tax. So if you're doing something you think is a wholesale business, you may in fact be doing a retail business, and there's no land tax that you can collect. That will make a huge difference.
Yes, it will.
They've made further changes to the child wellbeing and safety legislation. It came into effect last week, and it requires an organisation that does basically anything in relation to children to have systems in place for preventing child abuse, for reporting what do they call reportable allegations, and also investigating them. in conjunction with the police. So not interfering with the police investigation, but afterwards. It's going to make a huge change to lots of organisations that provide support and assistance, even if it's only incidental to children. It's going to be huge. And we had a question from last week. We had Peter from Parkdale, a friend's house. Somebody simply came onto his property and chopped down a very large tree.
At the front, that's right.
At the front, a metre across. He said the trunk was a metre across. Yep. Well, there's legislation in the Electricity Safety Act of 1998 that appears to have been breached. And ESV, Energy Safe Victoria, or a distribution company or a transmission company may exercise the power to enter onto land at a reasonable time for the purpose of inspecting the line and to remain on the land for that purpose. The power with the agreement of ESV to order that the power upon in production of the document in particular form and issued by the relevant company to enter on and to do whatever works are necessary to fulfil its responsibilities under the Act, and that includes making the line safe. But there's some paperwork that you've got to produce. And
it would seem it had not been produced.
It would appear from the discussion we had that there was no paperwork produced that justified the steps that were taken.
Yeah, you can't just turn up and do it.
Say, hi, I'm here, I've got a very large truck and I'm going to pull down your tree.
Yeah.
No.
Yeah. So it seems as if it was done without the proper procedures being followed, which then still leaves the question, what, if anything?
Well, you would have a claim for compensation because it was an unlawful... if it was an unlawful entry on your land...
For the loss of a tree.
For the difference between the value of the tree with and without the pruning.
Right. So what do? You haven't suffered any permanent loss because you can grow another tree.
But
how do you put a dollar value, a monetary value?
Trees are worth an absolute squillion. Mature trees are worth tens of thousands of dollars.
So it could be worth proceeding.
It could well be worth proceeding. I would be starting with getting the paperwork. I'd been probably talking to Energy Safe Victoria and asking for copies of the certification.
Why are trees worth so much? Is it because you argue that...
No, because they take so long to grow.
A house with a mature garden is worth much more than the same house without the mature garden.
Yes. So you could, a tree that's 3 metres high might be worth $15,000. So...
I'm going to reassess the value of the garden.
Okay, plant something bigger. Yes.
No, we actually had to cut one down. It was getting too big.
Well, mature trees, because they take so long, you think of an oak tree that's 100 years old. It takes a very long time before you can enjoy sitting underneath the spreading branches.
Yep, that makes absolute sense.
And that's it, John.
Okay, let's grab Dan in Werribee, who's first up this morning. Good morning to you, Dan.
Good morning. Thanks, John. Thanks, David.
Dan.
I had an accident on my push bike and I hit a car on the left-hand side of the guard, and as I hit that, I fell into the bonnet and dented the bonnet as well.
Oh, dear. Were you okay, Dan?
Yeah, I was quite fine. I straightened up the wheel after I gave my information and details and what have you. And
are you a large man, Dan?
67 kilo.
Did you hit with some force?
No, that's not large.
Did you hit with some force?
No, not really. I wasn't travelling that fast, no.
Okay. How can we help you, Dan?
I've got the insurance. They phoned me up and said they wanted my insurance policy, and I said, I was on a push bike, blah, blah, and they've sent me a bill for over $6,000.
Dan, ask for a copy of the quote. You actually want to see what kind of car was it?
It was a blue coupe, 2016 model. Hatch, three-door hatch.
The issue is a three-door hatch. Okay, that tells me it's probably... Anyway, never mind, let's keep going.
A newish car is the point.
A newish car. Look, it doesn't surprise me, Dan. Car repairs are incredibly expensive, particularly with fancy paints and panel matching and all the rest of it. You can get a copy of the quotation.
They sent me that. And
yep.
And a lot of things are on the right-hand side.
Yes.
And even on the grille and the bumper.
Well, then you ought not be paying for that. What I would suggest you do is see if you can look on the net and see if you can find some motor vehicle assessors, and you might get them to be able to tell you which bits are inappropriate for the damage that was caused.
motor vehicle assessors.
Yeah, so you want an assessor. You need to tell them who the insurance company is.
Yes.
Because some of them act for insurance companies and don't want to lose a customer over a one-off like Dan from Werribee. But you'll find people who'll be able to look at the quote, tell you what items match your description, and you then go back to them and say that you've had it assessed and you're happy to pay the following items but not these ones.
Right.
Because from what you've told us, everything is on the left-hand side of the car.
Correct.
Yes, that's the process.
How do I go about that again? Get online.
Online, you look on a search engine, you're looking for motor vehicle assessors, and they will give you estimates of the damage, the cost of fixing the damage on the relevant side of the car.
Okay. I'd have to send them off the details.
They can do it from the quote.
Okay.
Now,
Good.
Dan, when you said that it was your fault,
Yes.
was it 100% your fault?
Yes.
You're sure of that?
Yes.
It's almost never 100% someone's fault.
It was mine. This time, yes. Pretty much,
Okay.
yeah.
David,
What happens, Dan, is that in every accident there's normally an apportionment. It might only 10% or 20%.
can save you a lot of money, though.
And you think about an intersection accident. Well, somebody might have run a red light, but you weren't paying. There's lots of situations where it's both people's fault. You imagine two cars backing out of car parks, and you'll find that they touch. Well, who was at fault and who wasn't?
Yep.
But if you say it's 100% sure yours, that's great from the insurance company's point of view. But now what you need to do is actually work out what were the repairs on the left-hand side of the car that you're liable for, and what are the other ones.
Now, there's a free legal service out your way, Dan, if you're having trouble. I'm not sure their attitude to car crash claims and the like. A lot of them have said, look, there's just so many, we can't help you with those. But you might want to get some advice on how to draft your letters back to the insurers in order to save yourself some of that $6,000, okay?
Yes, thanks very much. Thank you.
Look, good luck. It's it's highly traumatic. Tim in Altona. Morning to you, Tim.
Hi, John. How are you?
Good, welcome aboard.
Good.
How can I help you,
Hi,
Tim?
Hi, David. Yes, I received a red light camera fine back in April as a result of obviously going through a red light. At the time, I thought I had a case to dispute it, because if I had not gone through the red light, which was very, very close, I would have been rear-ended by the vehicle behind me, who was obviously intent on going through with me.
And did the person behind you go through with you?
No, they stopped before the intersection.
Yes.
But I saw it coming, and so I actually went through the light. And in the photos, you can see my brake lights are on. You can see that I'd gone through, but I was on the brakes. I've been advised that very few red light camera disputes are successful, and it's coming up this Friday. And I'm just thinking, am I able to cancel or just pay the fine?
You would be able. Well, you can't just pay the fine. What you would need to do would be get the registrar to revoke the. So you need to talk to the camera office, and you'd need to get them to revoke the court proceedings. But it's very unlikely that they would do that, given that you're only sort of 4 days away. What you might do is talk to the prosecutor and tell them that you'll have a court reference number. You can talk to the prosecutors, and you can give them a call, and you can tell them that you intend to plead guilty.
Yes.
All right, and that could be made known to the court, and when the court's assessing the fine.
I see.
So, and whether you do it by letter or email or phone call, there'll be a process. And so if you do that, then your argument is, well, I haven't wasted very much of the court time because I have given them notice before they organised witnesses or a camera operator or anybody like that.
Okay.
All right, so, talk to the prosecutors. Was it presumably Melbourne Magistrates Court?
That's right, yeah.
And you talk to the police prosecutors probably a little bit after lunch, not that they're mellow at lunchtime, but
No, they're less busy.
They're less busy after lunch, so then have a talk to them then, all right?
Yeah.
So whoever's still got the camera list for Friday would be delighted to hear from you.
Okay, wonderful. Thank you.
Thank you, Tim.
Text messages. So money does grow on trees in relation to our discussion before about the value of trees.
Yes.
Boom, boom.
Trees grow money, yes.
Yes, and very good. And people saying some people's public liability insurance will cover you for cycling accidents.
Yeah, worth a look.
Worth a look,
For
certainly.
Dan.
And also, Alison from Victoria says that if you're a member of the group Bicycle Victoria, then you can be covered by their third-party insurance as part of your membership fee, which if you're a keen cyclist, it's probably well worth remembering.
And now that there are lots of people using more and more bikes on the road, it probably makes sense to insure your liability to third parties.
Indeed, it may well. Richard in Ballarat. Good morning, Richard.
Good morning, John, David.
Richard.
I'm a sole trader for IT services. Back in March, I was contacted by a representative of an IT firm in Melbourne to install 2 point-of-sale machines at an industrial complex in Ballarat.
Yes.
And they said the job needed to be done quickly. They sent me the paperwork the following day, the Friday. Work to be done Monday. It was supposed to be 2 hours work for a fixed fee of $250. I said yes. Did the work, although it turned out to be 4 hours because of logistical problems.
Yes.
I sent them several bills. They refused to pay. The person who contacted me no longer works for the firm. He gave me the name of the financial officer. She no longer works for the firm.
Oh,
I sent it to the I was given the name of the person who owns the firm, and no responses from him.
Richard, you can take the matter to VCAT if you want to.
Oh, can I? Okay.
Yes. You don't need to go to the magistrate's court. You can run it in VCAT.
Yep.
And what you might do is ask for a hearing in Ballarat, which will annoy them just a little.
Oh, good.
All right?
Yeah, because I read online that there's umpteen other people who have the same problem with this particular firm who actually went into receivership in 2015.
And has now come out of receivership?
Well, yes, and they're trading on the same name, but
or a similar name, but with a different ACN.
Well, maybe, yeah, but they were supposed to be taken over by some other firm, and this is information by other people online.
Richard, you've got to make sure you get the right defendant.
Right.
And you might actually suggest to other people that they might like to bring their proceedings at the same time as you bring yours.
Right. Knowing the liquidators at that time, was it going to be of any help?
Well, no. It's when did you do this work?
On about the 26th of March.
Then it's not the same entity that went into liquidation. It may be, it may have the same people behind it. It may be the same business, but it's not the same entity.
Yeah, well, on their paperwork, it's got their same name, company name anyway. But
yes, but it'll have a different ACN, or alternatively, it will have come out of receivership and is no longer affected by the receivership.
They actually give us Sydney addresses there on the letterhead.
You'll need to, doesn't matter, you perform the services in Victoria, you're to be paid in Victoria. VCAT has the ability to make an order that you can enforce in Victoria or, if necessary, in New South Wales.
All right, I hope
Richard.
that helps you, Richard. More calls in just a second. In breaking news, the Premier Daniel Andrews has announced a height limit on the tower that the City of Melbourne want to build next to the Queen Victoria Market. So the redevelopment of the Queen Vic Market, a lot of the money for the recapitalisation or the renovation of the market is to come from property developing the site that the council's acquired on what's called the Munro buildings, opposite the deli section of the market. And the state government have just announced a 125-metre height limit. So, David, 125-metre height limit, that's still quite high, but not as high as the City of Melbourne wanted the buildings to go.
Was it basically, so that'd be a 38 or 40-storey building?
30-something, yeah.
Yes.
So, yeah, anyway, the state government is saying you can't go as high as you wanted to. That's just come through. I like this text message. I know we don't take questions by text message because inevitably and invariably you have additional questions. I'm going to read this one out anyway, and it's not a question. A girlfriend's dog ran onto the road and was hit and killed by a insert name of luxury European car company. One of the hubcaps came off and was not recovered. A couple of weeks later, she received a bill for $1,000 for a set of new hubcaps. Apparently, you can only buy them as a set. I'm just counting the zeros. Yes, it's $1,000.
Okay.
$250 a hubcap.
Yes. My initial reaction was that if it was really expensive, it'd have alloy wheels in it, John. You could buy them at a wrecker.
Yeah, you can.
Yes.
Apparently.
Ouch.
Yes, not at all. Robert in Doncaster. Morning to you, Robert. Welcome.
Thank you very much, gentlemen. Look,
very hard to hear, Robert. I don't know if you can get closer to the phone.
Yeah. Is that any better?
A little. Keep going.
Yeah. Sorry. I purchased a property 2 weeks ago. It's a private sale through an agent, but the contract in Section 32 are in the form of like an auction contract.
Yes.
The contract's now unconditional, but I've just discovered yesterday that the vendor had not disclosed that he had received a fencing notice from one of the neighbours requiring the fence to be pulled down and repositioned on the correct title boundary, and the quote's about $6,000.
Reposition? How far are we moving the fence?
Well, it varies, up to about 1.5 feet.
Okay, so 450 mil.
Yes, and there's a retaining wall that'll have to be demolished to accommodate that change.
If someone agrees to the change, how old is the development, Robert?
It's about 10 years old.
The building's... okay, all right. Can you wait till next week, Robert? The questions that rise are this. Is first of all, while a vendor of property is required to provide certain information to a vendor, I'm not sure that a fencing notice meets the categories of the notices required. Right. All right, so if it is, then the failure to disclose it may give you the ability to avoid the contract. The second issue is that there's a difference in the area which the vendor now wants to provide to you as opposed to what you saw and inspected. Now, part of that will depend upon what your contract actually says as to whether there is any obligation. I mean, I see a contract these days that says, I'm only giving you so much of this land as is, only giving you so much of what you saw as is contained in the certificate of title. So, if you think about it, if you buy a property that's not perfectly positioned within its title boundary, are you buying the land in the title, or are you buying the land that you saw? And there's one crowd at the moment that produces a contract that basically says, I'm really giving you the lesser. So if the boundaries are wrong and they work against you, that's your problem. So there's really the two questions that need to work through. My recommendation is that you should go and see your solicitor or your conveyancer straight away. And I'll give you, everybody else, a broader answer next week.
A little more information on the Queen Victoria Market site. The council wanted a 70-storey tower. The government has limited it to 45 stories. So the council wanted to build something that was 190 metres tall, nearly 200 metres tall, 70 stories. And they've been told, no, you'll have 125, which is 45 stories high. And so they're moving... Go
away and do the numbers again.
So they're moving some of what was to go into that building, including social housing, to a different location as part of a deal that's been announced by the Premier, the Mayor and the Planning Minister, including heritage protections for Queen Victoria Market Precinct. And the Mayor will be here tomorrow, so we can go through some detail with the Mayor on tomorrow's program. Lisa in Ivanhoe, morning to you. You're through to David.
Oh, thanks for taking my call, David. I have a query. My child is enrolled in an early learning centre and has been there for some years. And recently we were de-enrolled for the following year because we failed to reply by the due date, which we were given a sort of a 2-week window. But the reason that I'm concerned about it, and I think that perhaps it's not they haven't followed due process, is because that they changed their processes for re-enrolment by sending an email. We had to send an email back, and previously it had been done by paperwork.
Yes.
And they didn't notify us that was going to change. There was also nothing in the email to indicate that if we didn't reply, we would lose our place for the following year.
Yes.
And they only sent the correspondence to one of the two parents, so they didn't send it to my partner. So I'm just wondering what sort of grounds we have to pursue this.
Oh, you could take them to VCAT.
Yeah.
Well, they've agreed to provide you a particular range of services,
yeah.
and they changed the basis upon which they negotiated with you to your detriment without adequate notice. Is the kind of argument that you would run.
Mm-hmm, mm-hmm.
So that's the suggestion I would put to them. Whether or not you take it all the way is up to you. But from their point of view, it's going to be a lot easier for them to add you back to the list and get you to acknowledge the changed processes than it is to argue whether or not you've been treated unfairly. When you contracted, what you've done is you've signed a contract or you've entered into an agreement with them to provide a particular range of services to your child in a particular time frame.
Mm-hmm.
And then And now they've come along and said, now, if you don't confirm that arrangement by these means within this time frame, the deal's off.
Yes.
I don't know it's quite that simple from their point of view. I can understand the administrative convenience.
Yes.
It's like you enrol your child at a school to start at a particular time, and 4 years later they write to you and say, well, are we still on? So
Yes,
so,
that's right.
But that's the argument that you would put, that you've never been unwilling to fulfil your arrangements, and that every discussion or communication you've had to date's been in a particular way. They've changed the basis of communication without telling you they were changing the basis of communication. Thank you, Lisa.
Good luck with that, Lisa. Can we squeeze in one or two after the news headlines? David Whiting, our talkback lawyer, but in the newsroom, Tim Callanan's got the headlines first, and thank you again, Tim. Back to your calls with David Whiting. Matthew in Castlemaine's been waiting patiently. Good morning to you, Matthew.
Yeah, hi. And hi, David.
Matthew.
Yes, I've got a really ludicrous story that illustrating the really sorry state of public dental care here in Victoria.
We specialise in ludicrous here.
Well, this is really ridiculous, this one. Half my life I've been on a disability support pension for illness. Now, I've gradually lost most of my teeth in the last 5 or 10 years. By the time you get to see a public dentist, for a filling, it's so bad they just remove your teeth pretty much. About 2 weeks ago, I was eating and one of my other teeth just cracked and got really loose. So I removed it myself with pliers, knowing that it's too hard to see a dentist.
Sorry, stop right there.
Yes.
With pliers?
Yes.
Oh, Matthew.
Yes. And so I thought, this is so...
Pain threshold must be very high, Matthew.
Oh, look, I've had as a spinal tap. I've had really painful things in the past.
Okay,
so a tooth is nothing. Anyway, so I thought, this is so ridiculous. So I put the tooth in an envelope with a covering letter lamenting the sorry state of dental oral health in Victoria, the worst in the developed world.
A letter addressed to whom?
To the Premier, Daniel Andrews.
Yes.
You sent him your tooth?
The tooth with a covering letter, okay?
And sorry, and did the covering letter say anything that was frightening or intimidating or bullying?
No, not at all.
Okay.
Anyway.
And did you send it to work, to his electoral office or to home?
To his parliamentary office.
Okay, yes.
And then about 5 days later, there was 2 policemen at my front door.
You did say it was ludicrous.
Yes. Were they returning it, were they?
No.
Okay.
It'd be good if they were a secret police dentist squad. That'd be good, but no. And they said, look, they threatened to charge me with stalking.
Yes.
Because I sent my tooth to the Premier.
Yes.
Isn't that just ridiculous?
Yeah, it's up there with ludicrous.
I'm sure. Were they in any way serious about that, Matthew, or just coming to check out whether you were completely nuts or not?
No. When they saw I wasn't like a lunatic and quite rational, they were sort of on my side.
Okay.
Now, is it possible they could charge me with stalking?
Absolutely. Is it likely you'd get a conviction? I would have thought Buckley's, Matthew, because it's Daniel Andrews would need to turn up to court and tell the magistrate that he felt intimidated or threatened as a result of receiving, as a result of having been sent, because he wouldn't have received it. It wouldn't have got past the mailroom.
Yeah.
But as a result of all of that, he felt threatened and intimidated by a tooth being sent by a Victorian. So
none of that's going to happen.
No. I mean, can you imagine they issue the proceedings and they try and get you to admit the offence?
No, I'd love if they did do it.
And in which case you come along and say, well, I'm going to plead not guilty, so let's see where the Premier's and my diaries interact and we can go to court.
Yeah.
It's not going to happen, is it, Matthew? But basically, the answer to your formal question is no.
Yep.
But your question about whether or not you attracted attention to dental care, well, you did by ringing this program, but you didn't by sending your tooth to the Premier.
I certainly wouldn't encourage it. That's why I wanted to know what the letter said. Because if the letter was threatening or intimidatory, then a stalking charge might well be justified.
they are.
Yeah.
You know, and they should be ashamed.
Are we saying how
of themselves.
disgraceful the individuals concerned are, or dental hair care in Victoria?
Dental altogether.
Matthew, I put the police visit down to a welfare check. They were just checking to see if you're okay rather than anything else. And
you know, they've got billions of dollars to waste on sports stadiums and the Grand Prix on endless freeways. But there's all these poor people with appalling oral health, one of the worst in the developed world, and you complain they send the cops round to your house? Jesus.
yeah, well, I'm glad you were able to get some free legal advice in relation to it, Matthew, and I'm sorry I can't also dispense free dental advice.
No, okay, thank you, though.
Good luck.
Bye.
Rebecca in Frankston South, good morning to you.
Good morning, John.
Yes.
Hello.
Hi, David. Thanks for taking my call. There's two parts to this matter. My partner, he runs a small business, and last November he was a victim of identity theft.
Yes.
And then fraud following
Yes.
that. So a number of accounts with a telecommunication company were open in his name, equaling quite a few $1,000s.
Yes.
And we've been trying to resolve that with that telecommunication
company. Yes.
Since December last year. And just due to their setup and their processes, it's not been an easy task.
Yes.
Just the last couple of weeks, my partner's received a text message from a debt collection agency
Yes.
stating that there's an outstanding debt with this telecommunications company.
Yes.
And that needs to be collected.
Yeah.
So with that, I was wondering what is the process that both the telecommunication company and the debt collection company supposed to notify us by? I thought we were supposed to receive written notification.
The debt collectors have a code of conduct about what they might do. I cannot imagine that it would preclude contact by SMS. They're certainly allowed to ring you, and they're certainly allowed to write to you. So they could send you emails. I can't see why they shouldn't be able to send you an SMS. But you need to go back to the telecommunications company and ask them, while your dispute as to identity theft is being investigated, why have they referred this to a debt collector?
Yeah.
And that was where I would be starting. And that might, in fact, be the basis of a separate complaint to the Telecommunications Industry Ombudsman.
Yep.
There is a dispute in place in train in relation to any liability whatsoever. Why has the telco gone and engaged a debt recovery company?
Yep, okay.
Yep.
If they do engage a debt collection company, are they supposed to tell us that they are doing that?
That rarely.
Okay, it just happens.
Yeah, well, it's almost you could come along and say, I could be acting for you, but I actually did have an issue with one of the telcos where I said I'm acting for Fred, and they wanted a copy of a letter from Fred confirming that I had the authority to act for them. But they wouldn't play the other game where the person I spoke to on the phone said, I'd really like to see your instrument of appointment from the board of your telco authorising you to represent them. They thought it worked very well one way and not the other.
Yes.
Goose is not good for the gander.
Correct.
Yes.
Lots of jokes about tooth fairies in relation to our caller with the ludicrous problems from Castlemaine, Matthew, a moment ago. And let's finish up with John from Williamstown. Morning to you, John.
Good morning.
John.
Thank you very much for taking my call, David and John. I'm ringing regarding my issue I've got with my house. I've had house foundation issues where I've had to have a lot of work done. It was at a lot of costs. Part of that contributed to the sinking of my house was tree root damage from some large, very mature trees on the verge of the nature strip. My searching of the internet has not found a lot of success in trying to get some sort of maybe compensation from the local council. Do you know anything about that sort of problem?
Have a look at the Road Management Act. The Road Management Act 2004 sets out what the council's responsibility will be in relation to roads that they manage. It's not particularly great. Is your house incredibly close to the nature strip, is it?
Well, I have these large trees that are, probably 30 or 40 feet high,
Yes.
and they're 10 metres from my house. They excavated under my house up to 2.5 metres.
Who is they?
Found they had to go that far because of tree roots.
This is council did this, or a contractor you engaged?
I had a contractor, an engineer, and I've had an arborist identify the tree roots that were causing the problem.
Yes.
So, the tree root caused drying of the clay foundations, which in turn caused my house to sink, which in turn caused me to have to get a whole lot of underpinning done.
I think the general proposition is that the Road Management Act will give the council the excuse that they need, and my suggestion is you probably look at a root barrier.
Right.
I mean, the
so
council.
Do I need to put that in, or can I get the council to put it in?
Well, in a sense, that's the problem. There were a series of cases of people running along bush tracks, and the argument was the council had put down the bush tracks but hadn't allowed for tree roots to grow, and they were stumbled and they fell and they injured, so they wanted to sue the road authority for not maintaining the running track as well as they might have. The reaction was the Road Management Act, and it limits the responsibility of the councils. I'll cover it next week. I don't see that the council has a responsibility to you, but and I think the most effective way would be a root barrier that you put in.
Good luck with that, John, and we'll certainly see David back in the studio at the same time next week.
Thank you, John.
In order to deal with any of your questions that you didn't get to ask today, and also for some follow-up. Apologies to those of you waiting. It's always a popular segment, but we are out of time. It's 11:15 on ABC Radio Melbourne.